The next question we have is with regard to certificates of compliance. And the question says, I recently purchased a property and upon calling out an electrician to connect security cameras around the property, this electrician that I hired then says to me that, look, doesn't know how a certificate of compliance was actually issued in the first place, because there's some serious issues with the electrical work on the property itself. And the property has now been registered for a week. The person who asked the question says, we escalated it to the bond attorneys and the real estate agents. We were advised to take it up with the electrician that the seller used. Is this our responsibility as the purchasers? Are we liable for the costs to fix the issues raised? That's the first question. And Angelique then asks a second question. Angelique is a first-time buyer. She wants to know who issues a certificate of compliance and when is this supposed to happen? Bruno?
So Occupational Health and Safety Act has a couple of regulations regarding obviously safety in property. So one of those regulations is before you even market the property. So if you're considering marketing the property, you put it on the market, you need to have a certificate of compliance. In practice, that doesn't typically happen. We only get the certificates of compliance almost just before transfer. But it does mention that if you market the property, you should have one, and it shouldn't be older than a certain specified number of months. So having that COC, if you're going to sell the property, is an imperative. As the seller, it is law that you actually have that certificate, and there is no excuse not to. Now, going off on a slight tangent, I've had this argument with a lot of people that, for example, attend sheriff's auctions and go, well, the seller can't issue a certificate. The sheriff's not going to issue a certificate. It says, I, as the purchaser, need to issue a certificate, but surely it's not my obligation. That's not really the question. The bottom line is there has to be a certificate for the transfer to be passed. Yes, it's typically the seller's responsibility, but if the seller for some reason doesn't issue it, doesn't matter. Strictly speaking, for transfer to be passed, it needs to be issued by someone. And so in a sale and execution, the purchaser takes responsibility for this, so be it. And a normal practice when it comes to private sales, it's normally the seller's responsibility prior to transfer to the purchaser to issue a certificate of compliance regarding the electrical systems in the house. So that takes me to the second part of the question. So what exactly does the certificate cover? Now, remember, it's electrical installations. And there's been a whole bunch of debates, and I'm not an electrician, so I'm not even going to start getting to the technical points. But I've had electricians sitting before me fighting about whether the installations are appropriate or not, because they don't go and test every single wire through the house and make sure that everything works, every socket, every light fitting. That's not what it's supposed to do, right? They test the general installation, and if it looks like it works, it's connected properly, the power runs properly through the distribution board, they certify it. Just because there's certain outlets, for example, that have been blocked or disconnected, or they don't work, or somehow there's been some kind of breach at some point, they don't necessarily always notice that. And like I said, I'm not speaking on a technical basis. I just know that I've had this fight before with people, and I let them fight amongst each other because I had no idea what they were talking about, right? So, but there is grounds for that. So what is compliance? I think we do need to kind of narrow it down to say, well, the wiring is like pretty much normal. It's not that there's no issues at all and everything works perfectly. So that's just also something to consider. Cost is the seller's cost. It's the seller's responsibility. So now assuming that the second electrician got it right, and he understands that there's no way that the COC, certificate of compliance, could be issued, right? And that it was the installation, something's wrong with the actual system, and the previous electrician fudged the report, which happens. I've seen it happen. I've seen COCs being issued over properties where the seller can't even get access to the property. And, you know, people kind of sit there going, okay, well, we don't know, but you know what? those attorneys pass transfer anyway. So I've seen it happen. It's not the first time. So assuming that the second electrician is right, assuming that the installation is wrong or the certificate is wrong or forged or faked or whatever, the responsibility of this lies on the seller. So you as a purchaser have recourse against the seller to rectify the situation, or rectify it yourself, sue the seller for damages after the fact for the cost of rectification and the issuing of a new COC. I wouldn't go as far as to say you could nullify or set aside the transfer, because that is quite a big thing. So unless the electrical system is so bad and it's so material and costs so much money to repair that trying to set a sale aside is justifiable, firstly, it's rarely the case. The costs are generally a lot less than the value of the property, and the courts will consider it a hell of a lot easier to just claim damages than to try set the sale aside, especially after the transfer has taken place. So recourse here would be demand the repair or demand damages after you repair.
Thanks, Bruno.